couple of things. First of all of the clients that we do planning for, we do living trust-based planning so that the assets are within a living trust that administers those assets both while they're alive and well and while they're alive and disabled. And then upon their passing, it administers them after that to benefit either a spouse or descendants or whoever else that they'd like to benefit. Not everyone knows about that, although living trust-based planning has been around for quite a while now, and many people have heard of it. Another technique that we use that's relatively new is dealing with inherited IRA assets. And up to about a year ago, those assets were creditor protected because they were IRA assets. And then a case came down June of 2014 that said, basically, if you're not the person who contributed the assets and you can't contribute more assets to that plan, then we're not going to protect that from creditors, and that's fair game from a creditor standpoint. Now, people don't expect to have creditor issues, but some people out there will have creditor issues. A failed marriage, a failed business, a tragic accident. There's a million different ways, and I would encourage everyone to embrace asset protection planning, even though there are no storm clouds in the horizon, because those storm clouds have a way of sneaking up on us. Estate planning paradigm was we have to reduce the value of the assets as much as we possibly can to fit them underneath the estate tax exemption, because once upon a time the exemption was $600,000, then it slowly crept up to $1 million, then it crept up faster than that, and today it's all the way up to $5.4 million. So the old paradigm was squeeze those assets down to fit them under the exemption. Today, the vast majority of clients will not have an estate tax issue, and so it doesn't become a matter of compressing asset values. It becomes a matter of enhancing asset values, because the date of death value will be the cost basis to whoever it is that inherits those assets. So we don't want to compress them down. Rather, we want to enhance them if we can, so that the people who inherit them have a higher cost basis and a lower capital gains tax bill when those assets are sold. So that's changed the landscape quite a bit. And the other fairly recent change is some of the methods we've used to compress asset values. Family limited partnership in particular, the IRS is taking a very jaundiced view on, and they've never liked that type of planning because it can be very effective. And now there's proposed legislation out there that's really going to curtail it. Nothing is finalized yet, but there's proposed bills flying around. And if I had to guess, I'd say, sometime next year or the year after, there will be final legislation in place that says that they really crimp down on that. So estate planning is very personal. It's very dependent on what type of assets you have. It's incredibly dependent on what your family situation is and what you're trying to accomplish with these assets. So all those things come into play during every single estate planning engagement.